Justice Brian Hagedorn, opinion excerpts, Wisconsin Supreme Court, November 30th, 2021. Quote, where the political process has failed and modified maps are needed before the next election, the court's function is to formulate a remedy, one tailored toward fixing the legal deficiencies. End of quote. Quote, the majority opinion asserts that only legal requirements may be considered in constructing a fitting remedy. That is not quite correct. Legal standards establish the need for a remedy and constrain the remedies we may impose, but they are not the only permissible judicial considerations when constructing a proper remedy. End of quote. Quote, suppose we receive multiple proposed maps that comply with all relevant legal requirements and that have equally compelling arguments for why the proposed map most aligns with current district boundaries. In that circumstance, we still must exercise judgment to choose the best alternative. End of quote. Quote, for example, one universally recognized redistricting criterion is communities of interest. It is not a legal requirement, but it may nonetheless be an appropriate, useful, and neutral factor to weigh. End of quote. With this in view, parties are invited to submit congressional and state legislative maps that comply with all relevant legal requirements and that endeavor to minimize deviation from existing law. Parties should explain in their proposals why their maps comply with the law and how their maps are the most consistent with existing boundaries. Parties should not present arguments regarding the partisan makeup of proposed districts. While other traditional redistricting criteria may prove helpful and may be discussed, our primary concern is modifying only what we must to ensure the 2022 elections are conducted under districts that comply with all relevant state and federal laws.